Hi, today we will talk about the very famous case Kesavananda Bharati versus the state of Kerala. Kesavananda Bharati Shripadagalvaru and Oz versus State of Kerala and ANR. Writ Petition, Civil, 135 of 1970, also known as the Kesavananda Bharati Judgement, is a landmark decision of the Supreme Court of India that outlined the basic structure doctrine of the Indian Constitution. The case is also known as the Fundamental Rights Case. The court asserted its right to strike down amendments to the Constitution that were in violation of the fundamental architecture of the Constitution. Justice Hans Raj Khanna asserted through the Basic Structure Doctrine that the Constitution possesses a basic structure of constitutional principles and values. The court partially cemented the prior precedent Golak Nath versus State of Punjab, which held that constitutional amendments through Article 368 were subject to fundamental rights review, but only if they could affect the basic structure of the Constitution. At the same time, the court also upheld the constitutionality of the first provision of Article 31C, which implied that amendments seeking to implement the directive principles, which do not affect the basic structure, shall not be subjected to judicial review. The doctrine forms the basis of power of the Indian judiciary to review and override amendments to the Constitution of India enacted by the Indian Parliament. The 13-judge Constitution Bench of the Supreme Court deliberated on the limitations, if any, of the powers of the elected representatives of the people and the nature of fundamental rights of an individual. In a verdict divided 7-6, the court held that while the Parliament has wide powers, it did not have the power to destroy or emasculate the basic elements or fundamental features of the Constitution. When this case was decided, the underlying apprehension of the majority bench that elected representatives could not be trusted to act responsibly was unprecedented. The Kesavananda judgment also defined the extent to which Parliament could restrict property rights, in pursuit of land reform and the redistribution of large landholdings to cultivators, overruling previous decisions that suggested that the right to property could not be restricted. The case was a culmination of a series of cases relating to limitations to the power to amend the Constitution. Facts of the case. On February 1970, Swami Kesavananda Bharati, senior plaintiff and head of the Hindu monastery Ennaya Matha in Ennaya, Kasaragod district, Kerala, challenged the Kerala government's attempts, under two land reform acts, to impose restrictions on the management of its property. A noted Indian jurist, Nanabhai Palkiwala, convinced Swami into filing his petition under Article 26, concerning the right to manage religiously owned property without government interference. The hearings consumed 5 months, and the outcome profoundly affected India's democratic processes. The case had been heard for 68 days, the arguments commencing on October 31, 1972, and ending on March 23, 1973, and its judgment consists of 700 pages. The judgment. The Supreme Court reviewed the decision in Golak Nath versus State of Punjab, and considered the validity of the Article 24th, 25th, 26th and 29th Amendments. The case was heard by the largest ever Constitution bench of 13 judges. The bench gave 11 separate judgments, which agreed in some points and differed on others. Nanabhai Palkiwala, assisted by Fali Nariman and Soli Sorabji, presented the case against the government in both cases. Majority judgment. Upholding the validity of Clause 1 of Article 13 and a corresponding provision in Article 368(3), inserted by the 24th Amendment, the court settled in favor of the view that Parliament has the power to amend the fundamental rights. However, the court affirmed another proposition also asserted in the Golak Nath case, by ruling that the expression amendment of this Constitution in Article 368 means any addition or change in any of the provisions of the Constitution within the broad contours of the preamble and the Constitution to carry out the objectives in the preamble and the directive principles. Applied to fundamental rights, it would be that while fundamental rights cannot be abrogated, reasonable abridgment of fundamental rights could be effected in the public interest. The true position is that every provision of the Constitution can be amended provided the basic foundation and structure of the Constitution remains the same. The 9 signatories to the statement were Chief Justice S. M. Sikri, J. M. Shelat, K. S. Hegde, A. N. Grover, B. Jagan Mohan Reddy, D. G. Palekar, H. R. Khanna, A. K. Mukherjee, Y. V. Chandrachud. 4 judges did not sign the judgment. A. N. Ray, K. K. Matthew, M. H. Beg, S. N. Dwivedi, S. M. Sikri, Chief Justice. CJISM Sikri held that the fundamental importance of the freedom of the individual has to be preserved for all times to come and that it could not be amended out of existence. According to the Chief Justice, fundamental rights conferred by Part 3 of the Constitution of India cannot be abrogated, though a reasonable abridgment of those rights could be effected in public interest. There is a limitation on the power of amendment by necessary implication which was apparent from a reading of the preamble and therefore, according to the learned Chief Justice, the expression amendment of this Constitution in Article 368 means any addition or change in any of the provisions of the Constitution within the broad contours of the preamble, made in order to carry out the basic objectives of the Constitution. Accordingly, every provision of the Constitution was open to amendment provided the basic foundation or structure of the Constitution was not damaged or destroyed. Shailat and Grover held that the preamble to the Constitution contains the clue to the fundamentals of the Constitution. According to the learned judges, Parts 3 and IV of the Constitution, which respectively embody the fundamental rights and the directive principles, have to be balanced and harmonized. This balance and harmony between two integral parts of the Constitution forms a basic element of the Constitution which cannot be altered. The word amendment occurring in Article 368 must therefore be construed in such a manner as to preserve the power of the Parliament to amend the Constitution, but not so as to result in damaging or destroying the structure and identity of the Constitution. There was thus an implied limitation on the amending power which prevented the Parliament from abolishing or changing the identity of the Constitution or any of its basic structure. Hegde and Mukherjee held that the Constitution of India, which is essentially a social rather than a political document, is founded on a social philosophy and as such has two main features: basic and circumstantial. The basic constituent remained constant, the circumstantial was subject to change. According to the learned judges, the broad contours of the basic elements and the fundamental features of the Constitution are delineated in the preamble and the Parliament has no power to abolish or emasculate those basic elements of fundamental features. The building of a welfare state is the ultimate goal of every government, but that does not mean that in order to build a welfare state, human freedoms have to suffer a total destruction. Applying these tests, the learned judges invalidated Article 31C even in its unamended form. Jagan Mohan Reddy held that the word amendment was used in the sense of permitting a change, in contradistinction to destruction, which the repeal or abrogation brings about. Therefore, the width of the power of amendment could not be enlarged by amending the amending power itself. The learned judge held that the essential elements of the basic structure of the Constitution are reflected in its preamble and that some of the important features of the Constitution are justice, freedom of expression and equality of status and opportunity. The word amendment could not possibly erase the right to abrogate the pivotal features and the fundamental freedoms, and therefore, that part of the basic structure could not be damaged or destroyed. According to the learned judge, the provisions of Article 31D, as they hend, conferring power on Parliament and the state legislatures to enact laws for giving effect to the principles specified in clauses B and C of Article 39, altogether abrogated the right given by Article 14 and were for that reason unconstitutional. In conclusion, the learned judge held that though the power of amendment was wide, it did not comprehend the power to totally abrogate or emasculate or damage any of the fundamental rights or the essential elements of the basic structure of the Constitution or to destroy the identity of the Constitution. Subject to these limitations, Parliament had the right to amend any and every provision of the Constitution. H.R. Khanna H.R. Khanna has given in his judgment that the Parliament had full power to amend the Constitution. However, since it is only a power to amend, the basic structure or framework of the structure should remain intact. While as per the aforesaid views of the 6 learned judges, certain essential elements which included fundamental rights of the judgment cannot be amended as there are certain implied restrictions on the powers of the Parliament of India. According to the judge, although it was permissible for the Parliament to effect changes in the exercise of its amending power so as to meet the requirements of changing conditions, it was not permissible to touch the foundation or to alter the basic institutional pattern. Therefore, the words amendment of the Constitution, in spite of the width of their sweep and in spite of their amplitude, could not have the effect of empowering the Parliament to destroy or abrogate the basic structure or framework of the Constitution. This gave birth to the Basic Structure Doctrine, which has been considered as the cornerstone of the constitutional law in India. The significance. The government of Indira Gandhi did not take kindly to this restriction on its powers by the court. On the 26th of April 1973, Justice Ajit Nath Ray, who was among the dissenters, was promoted to Chief Justice of India, superseding three senior judges, Shelat, Grover and Hegde, which was unprecedented in Indian legal history. The 42nd Amendment, enacted in 1976, is considered to be the immediate and most direct fallout of the judgment. Apart from it, the judge cleared the deck for complete legislative authority to amend any part of the Constitution except when the amendments are not in consonance with the basic features of the Constitution. In the 1980 case Indira Nehru Gandhi vs. Raj Narain, a constitution bench of the Supreme Court used the Basic Structure Doctrine to strike down the 39th Amendment. The 39th Amendment was passed in 1975, during the emergency, and placed the election of the President, the Vice President, the Prime Minister and the Speaker of the Lok Sabha beyond the scrutiny of the Indian courts. Adopting this amendment was a move to suppress Gandhi's prosecution. The Basic Structure Doctrine was also adopted by the Supreme Court of Bangladesh in 1989, by expressly relying on the reasoning in the Kesavananda case, in its ruling on Anwar Hussain Chowdhury vs. Bangladesh 41 DLR 1989 App. D. 165 1989 BLD SPL 1. Thanks for listening. Best of luck and have a great learning time.